attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a LawCast series talking about the newest SEC and regulator statements on ICOs and related enforcement proceedings. The message from the SEC is very clear. Participants in initial coin offerings, i.e. ICOs, and cryptocurrencies in general need to comply with the federal securities laws or they will be the subject of enforcement proceedings. This message spreads beyond companies and entities issuing cryptocurrencies, also including securities lawyers, accountants, consultants, and secondary trading platforms. Moreover, the SEC is not the only watchdog. State securities regulators and the plaintiffs' bar are both taking aim at the crypto marketplace. Several class actions have been filed recently against companies that have completed ICOs. After a period of silence, on July 25, 2017, the SEC issued a Section 21A report on an investigation and related activities by the DAO, with concurrent statements by both the divisions of corporation finance and enforcement. On the same day, the SEC issued an investor bulletin related to ICOs. I have discussed the Section 21A report and statements by the divisions of corporation finance and enforcement in prior LawCast series. Since that time, the SEC has engaged in a steady flow of enforcement proceedings and statements on the subject. The DAO report centered on a traditional analysis to determine whether a token is a security and thus whether an ICO is a securities offering. In particular, the nature of a digital asset, also called a coin or a token, must be examined to determine if it meets the definition of a security using established principles, including the Howey test. The report also pointed out that the participants in ICOs are subject to federal securities laws to the same extent that they are in any other securities offerings, and that includes broker-dealer registration requirements, as well as securities exchange registration requirements, and the trading on the exchanges. Everything must be registered unless an exemption applies. On November 1st, 2017, the SEC issued a warning to the public about the improper marketing of certain ICOs, token offerings, and investments, including promotion and endorsements by celebrities. Celebrities, like any other promoter, are subject to the provisions of Section 17B of the Securities Act, including the requirement to disclose the nature, scope, and amount of compensation received in exchange for the promotion. I discussed Section 17B and securities promotion in general in my immediately preceding LawCast series. On December 11, 2017, SEC Chairman Clayton issued a statement on cryptocurrencies and initial coin offerings. In that statement, Clayton drilled down on the sudden rise of non-security ICOs, now being referred to as utility tokens, clearly conveying the message that if a token has attributes of a security, it will be governed as a security. To make the message even clearer, also on December 11, 2017, the SEC halted the ICO by Munchie Inc., disagreeing with Munchie's statements and conclusions that its token was a utility token and not a security. In fact, interestingly, securities or tokens can be subject to securities laws in their offerings and may later become a utility, but the offering itself becomes a securities offering. The Munchie halt was not the first ICO halt. On December 4, 2017, the SEC halted the ICO by PlexCorp, including outright fraud charges with the claims of its unregistered offering. The SEC has also taken aim at companies that are in the crypto space in general, having halted the trading of the crypto company on December 19, 2017, after a 2,700% stock price increase. This was not the first trading halt by a public company either. Others include American Securities Resources Corp., halted on August 24, 2017, First Bitcoin Capital halted on August 23, 2017. That Chow Group, CIAO Group, halted on August 9, 2017. And Sunshine Capital halted on June 7, 2017. More recently, on January 5, 2018, the SEC halted the trading of Ubi Blockchain Internet Limited, citing questions regarding the accuracy of the information in SEC filings and concerns about market activity, which was the epitome of an unexplained stock surge. On August 28, 2017, the SEC issued an investor alert warning about public companies making ICO-related claims. The alert specifically mentioned the trading suspensions and warned that ICO claims could be a sign of a pump and dump scheme. On January 4th, 2018, Chair Jay Clayton issued another statement, this time joined by Commissioners Kara Stein and Michael Piawar, commenting on the North American Security Administrative Association's, i.e. the NASAA's, statement made the same day. The NASAA is a group comprised of state securities regulators, which, among other functions, acts as a communication arm for the individual state regulators on important marketplace topics. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.